Good morning. I'm Misbah Shahjahan, and today we are going to look into the procedural requirements of a valid marriage under Muslim law. So, in today's presentation, we are going to look through the introduction, essential requirements of a valid Muslim, and lastly, conclusion. And in details, we'll go with the requirements of a valid Muslim marriage. So, introduction. So, the laws in pre-Islam Arabia were skewed in favor of men and discriminatory against women. We have all know the information about all this through our histories. We have learned a lot. Now, only a few blood relationships, such as marriages to one's real mother or sister, had account for polygamy. Now, marriages comes in all shapes, size, and divorce was simple and painless for men. Now, men's absolute rights and lack of checks and balances led to men depriving women for their basic rights. Now, let's look into the status of women in Islam. Now, women were given due status in Islam, and they were regarded as dignified member of the society. Now, the term nikah, we all know which is there in Islam, or the marriage which happens in Islam, refers to an Islamic marriage. Now, it is literally means to tie up together. Now, it is a both matrimonial contract and an instruction that grants women a unique and high social status. Now, the purpose of nikah was to ensure the stability in marriage by binding both the partners together for an indefinite period of time, and also require the women to be honored with mahar. So, mahar is we would say it could be a jewelry or a property, it could be anything, and mahar is something that the groom gives to the bride. Now, marriages became a civil contract in Muslim law under the Arabic term nikah, which is translated into the union of sexes. Now, what it means is that Prophet Muhammad sallallahu alaihi wasallam, marriage became a civil contract under this Arabic term, and it has since evolved into one of the most sacred social institution among the man, with equal importance of rights and importance according to both the sexes. Now, in Muslim community, chastity is forbidden and even frowned upon. So, a nikah contract, unlike a civil contract, cannot be time limited or cancelled if procreation is not possible at all. So, it is, however, a very devotional act on the part of the devotee towards the God. Now, however, from the perspective of the Muslim religion, it is very devotional act and entwining two souls to achieve the spiritual ends of continuing the main line. Now, let's look into the essential requirements for a valid marriage. Okay, so the essential requirements of the valid marriage. The first one is the marriage is valid. In Arabic, we would say sahih if the court recognizes it as legal. Now, a valid Muslim marriage must meet the following requirements. First one is the husband and wife, as well as the parties to the marriage must be competent. We'll look into the competent of the parties in the next coming presentation. Now, the parties' consent or the consent of their guardians must be freely given. The required formalities have been completed, and the contracting process should not be hindered in any way. And there must be no restrictions or impediments into entering into marriage of contract. Now, let's look into the competence of the parties. So, under competence of the party, age of puberty and sound of mind is the main thing that plays a role. Now, both the boy and the girl must be competent to enter into a marriage contract. We all know that if anyone has to come into a contract, let it be any type of contract or an agreement, the party should be competent. And same like that, even here, if a boy and a girl has to enter into a marriage contract, both of them should be competent. So the parties are competent if they have attained the age of puberty and if they are of sound mind. Now let's look into the age of puberty. Now under the Muslim law, the age of majority or for marriage or the dower and the divorce is not 18 years old. In these cases, the age of majority is taken to be same as the age of puberty. A person's sexual competency is supposed to be acquired by the age of puberty. So minors marriage. So, if we look into the minors marriage, a person who has not reached puberty at the age of 15 is considered to be a minor in Muslim law. As a result, if he or like she lacks the legal capacity to consent to marriage, the marriage of a minor without the consent of his or her guardian is also void, and the marriage is legal if the minor's guardians give consent on his or her behalf, which is not true. And as a result, the minor's marriage is only valid with the consent if the minor has the consent also with the guardian. So, under the Muslim law, there are few persons who are recognized to be the guardians. That is the father, paternal grandfather, brother, mother, and her uncle are said to be the guardians of the minor. So it is important to know that the father is given the right of guardianship in the marriage. So this right passes to the next guardian in order of the priority if the father is not present. Now, the most important thing here is to distinguish between the guardians of marriage and the guardians appointed by the court. Now, without the permission of the court, a guardian appointed by the court to protect the minor's person or property has no right into the contract of minor's marriage. And a guardian for marriage, on the other hand, does not need such permission. He can contract the marriage without the court's permission. Now, according to the Shia law, the guardians of the marriage changes, and also when the minor reaches puberty, any marriage contracted by another guardian must be expressly confirmed by the minor. Now, there were legislation acts that were passed by the court. Now, let's look into the Child Marriage Restrainment Act 1929 as amended in 1978. Now, here it talks about the marriage between minors as discussed before. However, subject to this act, the purpose of this law is to prevent marriages between people who are under a certain age limit. Just because that you hit the puberty at an age doesn't mean that you are capable of marrying and look after a family and take responsibilities of another person too. So this act applies to all the citizens of India and it also includes to the Muslims too. And the males should be 21 years old and the females must be 18 years old to marry. And this is according to section 2 of the amended act. Now, a child marriage is one in which one of the parties is under the legal age of the marriage, and it is illegal for the guardian or anyone else for them to perform this child marriage. Now, Section 7 of the Act states that violation of the acts are cognizable offences and the police officer can also investigate it. Now, some of the effects that the legislature has on the minors' marriage, including the Muslim marriages, are a marriage is not void if it is a child marriage within the Act, which I've said before. A person who contracts, directs, conducts, or performs a minor's marriage on the other hand, commits a cognizable offence and it is subject to Act's penalties. And the child marriage cannot be prevented under Section 12 of the Act by obtaining an injunction before the marriage takes place. The violation of such restraining order is also punishable. Now, the second one is the soundness of the mind. Now, both the parties must be of sound mind at the time of marriage. Persons of unsound mind lack the legal capacity to enter into a marriage contract, just like other contracts and agreements, because their own consent is not considered consent in the eyes of law. So, idiocy and lunacy are two types of mental illness, and if any people has this kind of mental illness at the time of the marriage, it is said to be void. Now, marriage of an innocent person. An idiot's marriage is said to be null and void, except during the lucid interval. A lunatic's marriage is null and void. So, a marriage guardian, on the other hand, may contract a lawful marriage with a person of an unsound mind. And the same rules of option of puberty apply to the marriage, even if the person is unsound or not. Also, an insane person whose marriage was contracted by the guardian, other than his or her father or grandfather, has the right to repudiate the marriage once he or she regains the consciousness. Now we have understood what are the essential requirements of the um, essential requirements for a valid marriage under Muslims, and also we've looked into the competence of the parties. So, to conclude, okay. So to conclude, if I were to give my legal opinion, we can easily conclude that under Muslim law, marriage is nothing more than a civil contract. It meets all the contract requirements, including the proposal, acceptance, free consent, and consideration. Now, if I give from a point of view, from the religious point of view, then Muslim marriage is a devotional act. There are religious and spiritual values in marriage. In addition to these secular aspects, it contains elements of sacred union of two souls of like spiritual purposes. And husbands and wives are commanded to love and respect each other in Quran. And it is described as a noble act to enjoy oneself and all. Also, marriage is considered as a sacrament in Islam according to Quran. Now, in the ultimate analysis, it can be said that the marriage in Islam is neither purely a civil contract nor a sacrament, but it is devoid of none but blending of the two. So, I hope you understood what all I have discussed here today. Thank you so much. Thank you.